NBA State of the Nation, Discourse 2025. The Nigerian Bar Association, under the leadership of Mazi Afam Osigwe, Senior Advocate of Nigeria, cordially invites the general public to the NBA State of the Nation Discourse 2025. The theme is Strengthening Local Government Autonomy in Nigeria, a dialogue on the impact and implementation of the Supreme Court judgment. Keynote speaker, Ejembi Echo, JSC, retired. Lead presenter, Charles Soludo, CFR, Executive Governor, Anambra State. Anchor, Seun Okinbaloye. The event will also have in attendance governors, attorneys general of states, Bello Lawal, President, Association of Local Government of Nigeria, Local Government's Chairman, captains of industries and relevant stakeholders. Date, 19 February 2025. Time, 9 a.m. Venue, NBA House, Abuja. Together, let's shape the future of local government autonomy in Nigeria. For more details, visit Nigerian Bar Association social media handles. Don't miss it. NBA State of the Nation, Discourse 2025. The Nigerian Bar Association, under the leadership of Mazi Afam Osigwe, Senior Advocate of Nigeria, cordially invites the general public to the NBA State of the Nation Discourse 2025. The theme is Strengthening Local Government Autonomy in Nigeria, a dialogue on the impact and implementation of the Supreme Court judgment. Keynote speaker, Ejembi Echo, JSC, retired. Lead presenter, Charles Soludo, CFR, Executive Governor, Anambra State. Anchor, Seun Okinbaloye. The event will also have in attendance governors, attorneys general of states, Bello Lawal, President, Association of Local Government of Nigeria, Local Government's Chairman, captains of industries and relevant stakeholders. Date, 19 February 2025. Time, 9 a.m. Venue, NBA House, Abuja. Together, let's shape the future of local government autonomy in Nigeria. For more details, visit Nigerian Bar Association social media handles. Don't miss it.
Almighty God, our Creator, we pray you to be with us in all our deliberations and to direct our endeavors so that we shall continue in all humility to glorify thy name and do that which is right and just for our profession, its members, our fellow countrymen, and our country. Amen.
Thank you. Right next to that will be please, can we have our seats? Can we please have our seats? You're welcome to this State of the Nation Discourse 2025, as organized by the Nigerian Bar Association. Our hope and prayer is that this conversation will lead to the strengthening of local governments across the country for the purpose of ensuring that our nation is stronger and better. So on that note, I'd like to quickly introduce the National President of the Nigerian Bar Association, Mazi Afam Osigwe. Even your president, and I no go clap for him. I do not have a list of all his ESCO members. As they come to me, I will introduce them. But seated here, we have the Attorney General of Kaduna State, Sule Shobo, SAN. The Attorney General of Jigawa State, Lawandi Baba. We have Professor Sylvia Ifeji. I hope I get them right. If I don't find me. The spelling. M.Y. Abdullahi San, Attorney General, Kogi State. Oluka Kayode Ajulo San, Attorney General, Ondo State. Lillian C. Oga, representing Enugu State. I don't know if they are attorney generals, but I have Olaotan Olusegun. I have Abiodun Aikomo, Oyo. Also seated, SAN Tobechukwuweke. Silvanus Tahir, SAN. Musa A. Atta, SAN. Sami Sumairi, SAN. Adedayo Adedeji, SAN. J.G. Taida, SAN. As we go on, introductions will be made, but we kindly request that guests are seated so we can focus and start as quickly as possible. It's on that note, I want to quickly, before then, introduce Yakubu Philemon, SAN, Agada Elechi. Please let's give them a round of applause. Agada Elechi, SAN, and of course my good friend, Emeka Obiebolu, SAN. So on that note, I want to respectfully invite the President of the Nigerian Bar Association, Mazi Afam Osigwe, to give us his welcome address. A round of applause for him, please. Oh, sorry. Okay, maybe when you come. Now. When you come up. Sorry, national anthem, please. Let's rise. Thank you very much. You may have your seat as I hand over the microphone to the National President of the Nigerian Bar Association.
Distinguished guests, His Excellencies, Governors of State, represented Attorney Generals of State, Attorney General of State, Learned Senior Advocates, Honorable Justice Ejembi Eko, retired the keynote speaker for this event, and all our distinguished guests. I welcome all of us to this discourse, hosted by the Nigerian Bar Association, to discuss the state of the nation with regards to local government financial autonomy. It is no longer news that in the last few days, up to 10 persons are reported to have lost their lives in Osun State as a result of supremacy battle between the People's Democratic Party and All Progressive Congress over control of the local governments in Osun State. The issue of democracy at the local government level remains a burning issue which should get all of us worried. On July 11, 2024, the Supreme Court delivered a landmark judgment reaffirming the autonomy of local government council over their finances. Despite these decisions and the clear what would appear to be the clear provisions of Section 7 of the 1999 Constitution, which guarantees the democratic system of local government, the political players and indeed members of the legal community appear to be unable to come to a conclusive position as to what should be the state of affairs. Many governors hold the view that the idea of financial autonomy for a local government in a federation is an anomaly. They argue that Nigeria being a federation, that local government is not a federating unit. Others contend that the issue is not about being a federating unit. They further contend that if the Constitution has provided for a tier of government and guaranteed the existence of democratic institutions at that level, and has also ensured that revenues accruing to the federation is shared between the federal government, the state governments, and local governments, it is not the place of state governments to argue that the local governments should not have control over their finances. In the wake of that Supreme Court judgment, which I had earlier referred to, many states, led by my own home state, have passed laws relying on Section 7 of the Constitution, which gives the state houses of assembly power to make law for the finances, structure, and administration of local government, to make laws requiring local governments to contribute to remit a part of their allocation to the state government. Their contention being that teachers and primary health care workers are employed at the state level and deployed to local governments, that allowing the local governments to have full control of their finances may lead to a collapse of the system, where teachers may be owed, primary school teachers may be owed, and healthcare workers may be owed, or there may not be a coordination. We have therefore decided to convoke this discourse, and we are not taking any position as an association. And we have brought people from the Association of Local Government of Nigeria, Attorneys General, and governors, and I hope that His Excellency Chukwuma Charles Soludo, Professor, Governor of Anambra State, will be here to throw an insight to this conversation. And the Attorney General, who unfortunately we are very sure would grace this occasion, is not personally here. But he is represented by T.A. Ghazali Esen, the Director of Civil Appeals at the Federal Ministry of Justice. And of course, to open the conversation is a retired Justice of the Supreme Court, Ejembi Eko, JSC, retired, live venture, because this is a conversation we must have. If people would be killed and law enforcement agencies are not able to stamp the authority over fight for control of local government council, and which many argue is a fight for control of the finances of this local government, not necessarily for the welfare of the people, then we must have this hard conversation and come up with a position that guarantees not only peace and security in our country, but ensures that the local government system, which is the closest level of government to the people, work, and the money allocated to them are deployed for the good of the people. I do not pretend to know what each of the speakers here will say, and like I said, I do not hold a particular position, but that may not be totally true. I hold the position that there must be democracy at the local government. I hold the position that all tiers of government must allow the local government to breathe. And I hold the position that the Constitution must be allowed to work. But then, so as not to appear prejudicial, I shall soon be yielding the stage so that we listen to the keynote speaker, listen to our panelists, and confront ourselves with these questions that need to be asked. But as I leave this stage, I will ask us whether the state of affairs in Osun State is a type we would want to see every day, where people are killed over control, not only of the local government, but of their finances, where every governor in power manages to achieve 100% or near 100% victory only at the local government election, but never in every other election. And also to ask ourselves whether the state independent electoral committees or commissions are not complicit in ensuring that democracy does not thrive at the local government level. But then I am quick to ask myself, what do I know? Ladies and gentlemen, I welcome all of us to this discourse, and I urge you to freely speak, remembering that at the end of the day, it's all about Nigeria. It's all about ensuring that democracy works for all of us. Because if we fail to get it right at the local government level, we may be setting a stage for greater calamities that may befall the nation. We may be setting a stage to ensuring that democracy fails at the grassroots level. You're all welcome. We're very grateful you've made our time to be here. Let the conversation start.
Thank you, Mr. President. I think another round of applause will be good for him. I mispronounced a name. Please, a round of applause for JD Tidy SAN, former General Secretary. Also representing the Honorable Attorney General of the Federation's Director Civil Appeal in the Federal Ministry of Justice, Tijani Ghazali SAN. I don't want to assume. We also have Ikechukwu Uwana, Attorney General, Abia State. Please, a round of applause. We have Yemi Akangbe SAN, Ejembi Eko SAN, Ebun, Oluwadegolua SAN, Atoyebi Oyetola SAN, Mutalubi Ojo, Chairman MBA Local Government Monitoring Committee, Olumuyiwa Akingboro SAN. Please, a round of applause for them. As we go on, introductions will be made, and we hope that we can get this on as quickly as possible. On that note, I quickly want to invite the Chairman, MBA Local Government Monitoring Committee, Adebayo Ojo SAN. 2 minutes. 2 minutes. I have a gavel here, and if you don't follow the 2 minutes, I will hit it hard. A round of applause for him as we take his opening comments, please. Welcome.
Yes. Thank you. My Lord, Honorable Justice Ejembieko, JSC retired, all other protocols duly observed. I adopt the statement as ably delivered by the President of the Bar, Mercy Afam Osigwe, SAN. In addition to that, let me say that we should all not deceive ourselves. The position before the judgment of the Supreme Court was delivered. From that date till now, the position has changed. Whether we like it or not, there is a judgment of the Supreme Court in place, and that is of the apex court. We just have to live with it, and it will be wrong for anybody to think you can tinker or try to compromise or circumvent the judgment of the Supreme Court. That will not only be illegal, but as well criminal, because all bodies, persons, and institutions must ensure full compliance with the judgment of any court, particularly Supreme Court, because after that judgment, there is where anybody can go. But let me also say that, in fact, most people don't know that just like what exists at the federal or the central government and subnationals, the state government. Same scenario also exists at the local government level. They have in place their own executive, which are the chairman and the vice chairman, just like you have the president and the vice president, the governor and the deputy governors. Likewise, they have also in place their own legislative houses. They have the speaker at that level. They also have the councillors who are members of their parliament. And by the same token, they have members of their cabinet too, like the supervised councillor for works, for health, for education, for agri, and what have you. So if other tiers of government are working effectively, we want to beg all those that are involved, especially the state government and the governors, also to allow the local government to breathe. At the heart of democratic governance is the rule of law. And thank God there is no state in this country without an attorney general. The attorneys general of respective states must assist their government to ensure that there is full compliance with the judgment of the Supreme Court. Anything beside that will be operating or toying with anarchy, and which will be against the oath of office and by our dictate as a legal personnel. Thank you all.
Thank you very much. Local government business is serious business in Nigeria. And there's a general belief that if we don't get it right at the local government, it will be difficult for us to get it right as a country. His Excellency, the Governor of Lagos State is here, ably represented by the Attorney General of Lagos State, Mr. Lawal Pedro, SAN. A round of applause for him, please. On that note, may I respectfully invite the representative of the Attorney General of the Federation and Minister of Justice to please give us his address. A round of applause for him to encourage him as he steps up. Welcome, sir.
My Lord, Honorable Justice Agent Bieko, JSC retired, our dear President of Nigerian Bar Association, our distinguished State Attorneys General here present, our distinguished members of the inner and the outer bar, distinguished guests, ladies and gentlemen. It is my great pleasure to be in your midst to address you on this pivotal topic to our nation's progress and prosperity, strengthening local government autonomy in Nigeria, a dialogue on the impact of the implementation of the Supreme Court judgment. I must state that this topic is quite opposite to the current times, in that there is no better time to engage ourselves as members of the bar on this topic than now. Therefore, I thank the Nigerian Bar Association for coming up with this discourse and having me here. There is no argument regarding the vital role the local governments play in our democratic system and the potential they hold to drive sustainable development, foster inclusivity, and enhance the quality of life for all Nigerians. Since the pre-colonial times in the history of Nigeria, government has always been close to the people through well-documented traditional institutions that governed the Nigerian people across the various ethnic groups. The 1999 Constitution of the Federal Republic of Nigeria, as amended, in Section 7, institutionalized local governments as the third tier of the government in Nigeria. The courts, especially the Supreme Court, have time and time again pronounced on the duty of the federal and state governments to recognize and impose the federal structure enshrined in the Constitution, which recognizes the constitutional position of local governments in Nigeria by mandating all state governments to ensure the continuity of local governments in their states. However, it is quite unfortunate that over the last few decades in Nigeria, in plain contravention of the constitutional mandate on state governments, local governments have only seen a great decline, as they are now nothing but a mere appendage of the state government, merely existing as a means of supplying extra funds for the state government, as opposed to being the grassroots government to cater to the immediate needs of the people. Primary health care and education, environmental sanitation, care of the markets, maintenance of street light, etc., all of which are within the purview of local government in Nigeria, have now been completely taken over by state governments, and what is worse, become neglected and abandoned too. It is therefore no surprise that Nigeria keeps appearing at the top of the worst global index in all these areas. The most unfortunate of the decline is the unconstitutional connivance by state governors and their state houses of assemblies to willy-nilly dismantle democratically elected local government structures without recourse to the rule of law and replacing them with their candidates. Local government structures had almost become extinct in Nigeria, and that necessitated the action taken by the administration of President Bola Ahmed Tinubu, who is a lover of democracy and rule of law, to immediately intervene through the filing of a suit at the Supreme Court in May 2024. I, on behalf of the Federation, took the Attorneys General of the 36 states in Nigeria to the Supreme Court in its original jurisdiction and sought for declarations towards the complete emancipation of local governments in Nigeria today. Thankfully, the Supreme Court, in its ultimate wisdom, granted all the reliefs we presented before it, and among the crucial pronouncement of the Apex Court regarding the independence of local governments in Nigeria was that Section 1, Sub 2 of the 1999 Constitution provides that no person or group of persons shall take control of the government of any part of Nigeria contrary to the provisions of the Constitution. By virtue of Section 1 Sub 2 and 7 Sub 1 of the 1999 Constitution, local government must be by democratically elected local government councils and no other body. And the government or administration of a local government area by a state government, governor of a state, local government caretaker committee, interim local government council, administrator, head of local government, or by whatever name called, or by any other state agency or other body is not in accordance with the 1999 Constitution, is therefore unconstitutional, illegal, and of no effect. Another groundbreaking pronouncement of the court is concerning the financial independence of the local government when it held that Section 162 Sub 5 of the 1999 Constitution merely provides for a method or procedure of getting the money, getting the amount distributed to local government councils under Section 162 Sub 3. Subsection provides that it should be given to the states to take to them, and subsection provides that for this purpose the state shall maintain a special account called State Joint Local Government Accounts, into which the state shall pay the allocation to local government councils from the federation account and revenue from the government of the state. Thus, Section 162 Sub 5 merely appointed the states agents of the federation to collect local government allocations from the federation account and pay to them, but does not give the states any right or interest in the said allocations to the local government councils from the federation account. The duty of the state is to simply convey to the local government councils the allocations from the federation account. The Constitution does not give the states any right or interest in the allocations to a local government council from federation account. The above pronouncement clearly establishes the autonomy of local governments in Nigeria and signals a hard-fought and won victory for governance in the grassroots. And we thank the Supreme Court for its boldness in giving power to the provisions of the Constitution. Aftermath of the judgment. Following the Supreme Court judgment granting total autonomy to the local governments in Nigeria and the injunction of the court to all governments in Nigeria to immediately implement the judgment, the federal government immediately set up an implementation committee comprising of representatives of the federal government, ALGON, and Nigerian Governors Forum. This committee has been working assiduously at coming up with the most practicable framework for the full implementation of the judgment, especially regarding direct payment of allocations from the federation account to local government councils. The committee is expected to complete its mandate anytime from now and present its recommendation to Nigerians. It is, however, imperative to state that despite the judgment of the Supreme Court outlawing the illegal removal of democratically elected local government councils by state governors, it is quite unfortunate that few states have continued to blatantly carry on with this illegality. Let me state in unequivocal terms that this act is tantamount to treason and must be treated as such. Now, while it is true that Section 308 of the Constitution grants the governor immunity from prosecution, I wish to be clear that this flagrant disobedience to Supreme Court judgment will have unpleasant consequences for the state as a whole, should it persist. More importantly, I must reiterate here, at this significant gathering, considering the presence of state attorneys general and other important stakeholders, that we all have a moral duty as ministers in the temple of justice to promote the rule of law and respect for our courts. There is a worrisome trend in the legal profession these days, where lawyers, including the state attorneys general, allow their clients and political leaders to dictate the law to them when it should be the other way around. This is quite unbecoming of gentlemen of the bar, and it must be addressed and reversed immediately. We must all remember that we owe a duty to the Constitution of the Federal Republic of Nigeria before our political allegiances. Every state in Nigeria has an attorney general. Therefore, the failure of states to the local government structures in their states, in my opinion, can be attributed to the complete dereliction of duty by the attorneys general to the rule of law they swore to uphold. We must always be courageous as lawyers to always give the correct legal advice to politicians who believe they have the right to breach the sacred provisions of the Constitution, regardless of the grim repercussion. Again, let me remind us that we are all servants of the law and our duty is to defend the Constitution always. I therefore call on everyone present here today to lend their support to the full actualization of the full autonomy of local governments in Nigeria in line with the mandate of President Bola Ahmed Tinubu. Most importantly, local governments must also wake up to their constitutional duties by being accountable to the citizens, constantly improving themselves in areas of administration and capacity building of their staff, and constant community engagement to improve trust and transparency. There is no room for babysitting the third tier of the government anymore. There must be concerted efforts by ALGON to continue to improve the technical capacities of local government workers across Nigeria to be able to rise up to the humongous tasks ahead of them. Local government council must be seen to be alive with a reformed civil service structure and executing more impactful projects that will bring respite to the people in the grassroots, for whose sake this fight was won. I wish to once again congratulate the Nigerian Bar Association on this auspicious occasion and wish you all a most fruitful deliberation. Thank you all.
Another round of applause for him. Thank you for those very critical words. Director, sir, let me say on behalf of local governments that what they have is financial, not full autonomy. I can tell you that for free. The words are always juxtaposed. What they have is financial autonomy, it's financial autonomy, not full autonomy. It's on that note, I respectfully invite to present the keynote address. First speaker, Honorable Justice Ejembi Eko, GSC. Yes, sir. Please. No, you can. Yes. 3, yes. Anyone? I give you the mic. He'll be giving an overview of the Supreme Court judgment and its constitutional implications, exploring the practical and legal pathways to ensuring local government autonomy and compliance with the 2024 Supreme Court ruling.
I stand on existing protocols. Ladies and gentlemen, the President of the Nigerian Bar Association, I acknowledge your very efforts. Congratulations. Because the time is far gone, I have a written paper. As much as possible, I'll try to guillotine. Firstly, let me appreciate and thank the organizers of this auspicious talk shop. The team are very dear and crucial at this very important moment in our nascent democracy. The theme of the 2025 discourse is strengthening local government autonomy, a dialogue on the impact and implementation of the Supreme Court judgment. It is assumed, albeit erroneously, that the particular judgment of the Supreme Court of Nigeria, the sine of this year's theme, is known to all, including the organizers and the participants. My guess is that the particular judgment we have in mind is the one said to have declared the financial autonomy of the local government in Nigeria. And it is the suit number SCCV 343/2024. The Attorney General of the Federation and the Attorney General of Abia State and 35 others. This is the first bold step ever taken by the Attorney General of the Federation to bring to bear or to try to enforce a particular provision of the Constitution that will support the nascent democracy we are participating. Autonomy presupposes independence, freedom, liberty, self-determination, self-government, self-rule, or sovereignty. The antonym of autonomy is dependence, appendage, or the state of being subservient. Heeded to the recent decision of the Supreme Court on financial autonomy of the local government in Nigeria, the issue had been whether state functionaries can exercise powers to suspend, dismiss, or dissolve democratically elected local government council, including the chairman, vice chairman, or the councillors. The question had always turned on the interpretation of Section 7, subsection 1 of the 1999 Constitution, which I reproduced. The Supreme Court had consistently struck down the provisions of the various state local government laws empowering the governor to suspend, dismiss, or dissolve a democratically elected local government council, and in the state, appoint transitional or caretaker committee to run the affairs of the local government. Take, for instance, the Supreme Court decision in Ajuon against Governor of Oyo State in 2021 that struck down sections 11 and 21 of the Local Government Law 2001 of Oyo State that empowered the state governor on the recommendation of the House of Assembly to dissolve and dismiss elected local government council, including the chairman, vice chairman, and the councillors, and replace them with his handpicked men to run the affairs of the local government. The court took similar stance in previous decisions. Attorney General of Benue State against Umar, Attorney General Plateau State against Guyur, Eze against Governor of Abia State, Governor Ekiti State against Olubumi. They are there in the law reports. In all the above cases, the court took a position in effect that the existence of the provisions like sections 11 and 21 of the Local Government Law 21 of 2001 of Oyo State posed real and existential threat to the system of democratically local government guaranteed by section 7(1) of the Constitution, the intent of which is to vouchsafe the inviolability of the sacred mandate which the electors at the local grassroots level democratically donated to the local government chairman and the councillors. In Ajuon, the governor of Oyo State, and the governor of Oyo State, it was stated poignantly that the local governments are neither mere appendages nor parastatals of the state. And it appears the governors seem to take the position that they are mere parastatals which they can willy-nilly deal with and even tamper with their funds. The question, why are these our democratically elected governors constituting themselves into a body of anti-democracy species most dangerous to the Constitution and democracy in Nigeria? MBA and our jurists must find an answer to this question. Again, why are the governors, notwithstanding the avalanche of decisions of our law courts, including the Supreme Court, still adamantly being recalcitrant and unyielding to upholding the Constitution and the rule of law, a major covenant in their oaths of office, which they respectively subscribe to before taking up their various offices? What do we do with the attorneys general who counsel the governors to flout the Constitution and desecrate the rule of law? The financial autonomy. In the aforesaid Attorney General of the Federation against Attorney Generals of the 36 states, the plaintiff, the Attorney General of the Federation, raised a fee 8 and 9 sought the court in substance to hold that the failure of the states to organize elections and put in place a system of democratically elected local government councils in their respective states was an act of dereliction of constitutional duty, and that the system of self-serving caretaker committees put in place by them to administer the local government was unconstitutional and illegal. The court had no difficulty in answering the questions in agreement with him, particularly in view of the subsistence of some of the earlier decisions, including the earlier mentioned ones. It may also be added that it amounts to the dereliction of the constitutional duty for a governor or any other state functionary to refuse to perform a constitutional duty imposed on him. It amounts also to abuse of office, contrary to paragraphs 1 and 9 of the Code of Conduct for Public Officers in Part 1, the 5th schedule to the Constitution for a public officer, including the governor, to do or direct to be done anything arbitrary, any arbitrary act prejudicial to the rights of any other person, knowing that such an act is unlawful and contrary to government policy. Paragraph 18(2) of the same 5th schedule provides inter alia that the punishment which the Code of Conduct Tribunal may impose for abuse of office in violation of the Code of Conduct for public officers shall include a vacation of the office or seat in the Legislative House, or as the case may be, disqualification from membership of a Legislative House or from any public office for a period not exceeding 10 years. You may, for purposes of interpretation, the question in paragraph 18, the question is whether it also includes the governor, but that's a different matter altogether for now. Issue 7 imposed by the plaintiff is whether a state in breach of Section 7 and 162, 5 and 6 of the Constitution is entitled to receive and spend funds meant for the local government council while in breach of the Constitution for not putting in place a system of democratically elected local government council. The answer was emphatic no by the Supreme Court. The substance of issues 11, 12, 13, 14, and 15 posed by the plaintiff includes whether, on account of the state failing or refusing to put in place a system of democratically local government councils, the state has unbridled or non-restricted discretion to operate state joint local government account whimsically to the disadvantage of the local government, whether by virtue of Section 162, subsection 6 of the Constitution, the state is not an agent of the local government in the collection of the amount standing to the credit of the local government. The Supreme Court did not mince words in the declaration that all amounts standing to the credit of the local government from the federation account and to the state belong to the local government and is therefore entitled to be so paid. The point was further reiterated by the judgment by the Supreme Court in the judgment that by Section 162, subsection 3 thereof, the Constitution does not intend joint ownership of any amount standing to the credit of the local government from the federation account and the state. And the state and the local governments are each entitled to the amount standing respectively to their credit from the federation account. The Constitution does not intend that the state shall retain the money distributed to the local government constitutionally as the third-tier government, and that the state's unilateral retention of the money meant for the local government from the federation account is illegal and unconstitutional. In other words, the state, by virtue of Section 162 of the Constitution, has no right to withhold, hold, or retain any money belonging to the local government. The judgment, therefore, has stated the position or the financial autonomy of the local government qua the state poignantly and beyond reasonable doubt. Much as we hail the Supreme Court for this local government financial autonomy judgment, the next question that needs to be asked is whether the learned justices of the Supreme Court had not unwittingly amended or rendered moribund and or inoperable Section 162, subsections 5 and 6, which provides that 5, any amount standing to the credit of the local government in the federation account shall be allocated directly to the state for the benefit of the local government councils on such terms and in such manner as may be prescribed by the National Assembly. But I'm aware that the National Assembly has not made any act to this effect. Subsection 6, each state shall maintain a special account to be called state joint local government account, into which shall be paid such allocations to the local government councils from the federation account. And if indeed the Supreme Court had unwittingly and inadvertently, as the critics are suggesting, amended the Nigerian Constitution by the subject local government financial autonomy judgment, will the judgment not be a killjoy on a simple fact that the Supreme Court had outrageously assaulted the very constitution that it was upholding, a malfeasance that is forbidden of the court to so do. Nothing in the constitution permits the Supreme Court to legislate, and it is ultra vires the court to amend the constitution or any its statute, or by its own decision render inoperable any statutory provision. The function of the local government, the function of the court is simply jus decree, not to make laws. They have no constitutional right to amend or to add to any statute, including the Constitution. There's nothing like judicial legislation or legislative judgment in the judicial powers vested in the Supreme Court, like any other law court under our Constitution. Issue 10, raised by the plaintiff, is to the effect that whether the governor or any other state official who may have illegally caused or directed the dissolution of a democratically elected local government council could be liable to be prosecuted either during or at the end of the tenure, as the case may be, for criminal offenses bordering on breach of constitution and or contempt of court, or any other criminal or penal laws was not answered. And that was because it was hypothetical, just as it was seeking the court's advice. Nigerian courts do not entertain hypothetical questions. They also have no advisory jurisdiction, unlike the Supreme Court of India. I had earlier in this paper stated, and it was not in the subject judgment of the Supreme Court, that abuse of office is a serious public offense in the 5th schedule to the Constitution, the Code of Conduct for Public Officers. The jurisdiction to try any person for the offense, for the said offense, resides and is vested in the Code of Conduct Tribunal. It appears it does not. It appears it does not avail a governor to plead his immunity, which is a debatable question. Under Section 308 of the Constitution, does it not sound unreasonable for the man violating the Constitution to plead his cover in its shredded form? St. Paul of Tarsus in the New Testament, in the Holy Bible, says, reasoned, he who does not acknowledge the law shall be adjudged without it. The Supreme Court of Nigeria in Asari Dokubo against the Federal Republic of Nigeria 2007 had attempted to answer this question at page 38 of the Ligapedia. Law Pavilion, electronic version, page 38, IT Mohammed JSC, then as it was. He appears to concur in the jurisprudence while dismissing the bail application of Asari Dokubo, who was standing trial for treason, that where national security is threatened or there's real danger of it being threatened, human rights or individual rights of those responsible must take second place. Human rights or individual rights must be suspended until national security can be protected or well taken off. It goes on, this is not new. The corporate existence of Nigeria as a united, harmonious, indivisible, and indissoluble sovereign nation is certainly greater than the citizens' liberty or right. Once this security of the nation is in jeopardy and it survives in pieces rather than in peace, the individual's liberty or right may not even exist. It follows from this argument, therefore, that the state governor whose physical banditry being the ulterior purpose of his violating the Constitution, as well as renouncing the covenant in his oath of office to eschew corruption and to protect the Constitution, cannot and should not be held to invoke his immunity under Section 308 of the Constitution if and when he is charged or arraigned before the Code of Conduct Tribunal for trial upon information of abuse of office contrary to paragraph 9 of the Code of Conduct for Public Officers in the 5th schedule to the Constitution. Was that supposed to be noticed to me? Okay. Is it not time we limited the scope of the constitutional immunity for the state governor, since it is not serving any useful or functional purpose, as incumbents are abusing and or resorting to this umbrage to commit all manners of maliciously criminal malfeasance, including unbridled corrupt practices that undermine the interests of their subject or citizen? For how long will our constitutional law remain an ass, doing nothing to prevent and punish the malignant evil to the society it was erected to guide, guard, and protect? For now, the bad boys are the state governor, who will lay and misuse the funds of the local government coming from the federation account. Is it not early to shout to Eureka? Since power corrupts and absolute power corrupts absolutely, we should now be thinking ahead on how to check the physical powers of the so-called executive chairman timelessly, if the financial autonomy of the local government is anything worth celebrating. And what about the lawyers whose humongous bills for election petitions are, to your knowledge, paid by the governor through the office of the Attorney General from the money stolen from the local government account? Are you not imperiled a little in the sordid and unwholesome practice? A person who participates criminally should also share in the guilt and the punishment for the offense committed, at least as a conspirator, as Jesus Christ would have scribbled on the land, on the sand, and told the lynching party, only he who had not committed an offense should cast the first stone on the adulterous woman. My learned friends, we cannot effectively fight this cause unless we inculcated in ourselves the principle of equity, insisting that we cannot come to equity with soiled and unclean hands. This should be my last word on it. And thank God the bell is telling me to shut up.
A round of applause for the Honorable Justice Ejembe Eko, retired but not tired. Thank you so much, sir, for that presentation. Thank you so much, sir. Very quickly, we'll get ready for the next panel. While we do that, let me also say that some very eminent personalities joined us in this event. We have Abdulaziz Sani, SAN, Attorney General of Zamfara State, Dr. Abdullahi Usman Bello, Chairman, Code of Conduct Bureau, Victoria Awo Molo, SAN, Yakubu Meikade, SAN. We have Dr. Monday Ubani. He's representing the President of the Senate, himself a lawyer. We have this was an error in the initial statement. Dr. Olukayode Ajulo is representing the Governor of Ondo State. We also have Dr. Ben Odo, Attorney General of Ebonyi State and Chairman Body of State Attorney Generals. We also have Dr. Junaid Bello Marshall, Attorney General of Kebbi State. Ogwefi High Chief Fideli Suma Nelika Malire. He's the Royal Majesty from the Kingdom of Anam in Anambra State. I hope I don't get to pay any fine. If I will pay, SN Emeka Obibolu will support me in one way or the other. Your Majesty, you're welcome to this event. Very straight to the next panel, which will take us for a bit of a round of applause again for his contribution, Justice Ejembe Eko. This panel has the Attorney General of Lagos State, and I'd like to invite him to the podium, Lawal Pedro SAN. This panel has the President of Algon, Engineer Bello Lawal, ably represented by one-time Chairman of Aru Local Government, Vibrant. This panel has Ebun Olu Adeboluwa SAN. This panel has Right Honorable Onofiok Akpan Luke. Are the microphones working, please? Sure. Okay. So I'll just give a very simple overview so that we'll understand what we are here to do. Sorry, it's 30 minutes, not 40 minutes, so that it's not ringing. The local government as it is today, when I hear it has autonomy, might not be the correct word. And I'll give you 3 practical examples. 1, you can be chairman of council, summon a security council meeting, and the DPO can refuse not to attend. You are chairman of council, you pay primary healthcare workers their salaries, but you don't control how they are moved from place to place. That is done Government Service Commission. You are chairman of council, you pay teachers their salaries, and yet it is Superb and the LEA who move them from place to place. So what does the local government chairman actually control? That will form part of this conversation. But importantly, on July 11th, a landmark judgment was given in this country. And I know, as a Nigerian, that there are many judgments that come and they take immediate effect. These are taking, we're getting to a year, and people are asking, why? I'm sure if it was a case of murder, judgment would have, there would be no state. I mean, Supreme Court is heaven. You can't go to another court. And so also other cases. SN Olu Ebu. What is the problem? Why is this judgment not implemented as it has come?
Thank you very much. I'd like to stand on existing protocol, acknowledging my Lord, the Honorable Justice Ejembieko and President of the Nigerian Bar Association, and all our colleagues from the inner and outer bar, and then fellow panelists. From my own understanding of the paper delivered by my noble lords and the judgment of the Supreme Court, the federal government is attempting to be a policeman of democracy by making efforts to control the other 2 units of the federation. Whether this is right or not will be left for the people of Nigeria, but there's a judgment. I understand that judgment is a policy decision of the Supreme Court, as my Lord has said, whether the Supreme Court has the power to amend the Constitution, as it has done. But because as lawyers we believe that that court has the capacity to make policies for the good governance of this country, once a decision comes, we accept that decision the way it is, especially under Section 287, Sub 1 of the 1999 Constitution. But from my observation, especially what's happening in Osun State currently, despite this judgment of the Supreme Court, I don't think anything has changed substantially. And I'll say that with respect to our collective experiences, I will just proffer some solutions that I think we can look at based on the paper delivered by my noble lord. The first thing is to find out how we can achieve unified tenure between the local government system and the state. Because once a governor comes afresh, he does not want to accept the existing structure of the local government. He will find a way to work with the House of Assembly to pass a law that will enable him to conduct election.
But I want us to stay on the judgment of July 11, why it has not been implemented in your own thoughts.
Yes.
We'll come to the other, there are a lot of issues, we'll come to them, but I want so that we can have other thoughts as quickly as possible. I'll come back to you.
Second reason why I think the judgment has not been implemented as it should be is because of the Houses of Assembly of the states. when there is no capacity, you can't blame whom you put in power. Look at what is happening in Lagos State currently in the House of Assembly. Unless we win independence for the Houses of Assembly of the states, the governor will continue to bypass this judgment.
They rejected their own independence. So you have given 2 points which are critical.
Yes.
I'll come back to you.
Thank you.
Attorney General Lagos, how are you, sir? This judgment is supposed to be beneficial to everyone. In your thinking, representing the governor and as Attorney General, after 7 months, what is delaying the direct implementation of that judgment?
Well, thank you very much, my Lord. And I stand on existing protocol. In my view, to some extent, the judgment is implementable and is being implemented halfway. The one that guarantees democratically elected local government council as pronounced by the Supreme Court. All the states that hitherto had caretaker are not conducting election for 1, 2, 3 years are now conducting election. So to that extent, the judgment is being implemented. Now, on the financial autonomy, the dynamics of the implementation, and I believe the Accountant General of the Federation and those of the states will come to it. If it is to pay local government directly from federation accounts, which in my view too is a bit contra to the present provisions of our constitution, it is. But if it is to do that, there shouldn't be any problem. It is after payment had been done. What happened to those areas where the state and local government joint account has been taken care of? And you know, you must go back to history. In 1979, the type of local government council we had was quite different. It is the 1979 Constitution, 1999 Constitution that brought out this problem. And unless the Constitution itself is amended to reflect whether to grant local government as a third-tier government full autonomy, both financial and administration, the Constitution had to be amended. As the Constitution stands today, and all most relevant law, I could see my honorable brother talking about superb, talking about health. All those are already intertwined with the state government administration. And it was because local government council were not paying primary school teachers salaries. People do not know the genesis of why the state and local government joint account was created and now inputted into the 1999 Constitution. It is to prevent this. In the past few years, have you heard that primary school teachers are not being paid? Now with this autonomy, the fear now is that how is those dynamic, both health, primary school, and other things that the state and local government are jointly responsible for. I think that's just the reason.
Attorney General, just back to you again. The law, as it is, most local governments in this country, employments are made for them by the state governments. That is a fact. And when it is done, because most local governments today have workers they don't need, and so the wage bill has increased tremendously. Now, if the argument is, because what you are saying is that the judgment is being varied, while one has been implemented, the transfer of funds to local governments directly has not been implemented for dynamics best known to the federal government. We want to know exactly what those dynamics are. Because if the judgment says pay, it is for CBN, Ministry of Finance, to request the account numbers of the various local governments across the country, but they have not done so. No local government has been asked to bring their account numbers to CBN or through Ministry of Finance. And that is the problem, and we're asking why.
Now, you have almost answered your question. Is it the state that is preventing local government submitting the account? It is the federal government. That's why I said the accountant general will have to request and pay it direct. Whatever come after it.
Attorney General is shaking his head.
Yeah. So the state cannot divide a local government for sub. In fact, the accounts should be known. But the point I want to make is that, to correct one thing, is that it's not that the states do employ. There are two. And I believe, talking for Lagos, there is what we refer to as Local Government Service Commission. It is that commission for the local government, which the state do not, apart from constituting the commission, does not take part in that. And local governments, like also in the mainstream service, have power to employ junior officers from level 1
to 6.
And state does not. It is the senior officers that the commission, like we have for teaching service commission.
Who does the commission chairman report to? Who does the commission chairman report to?
No, because they are part of, that's why I say they are part of the state executive bodies.
But they report to the governor.
But reports to the governor through the chairman of the Civil Service Commission.
No problem.
You can say so too.
Varies from place to place. Algon, this judgment was given in July. We are in February. Algon has not been saying anything. Is it out of fear of the Houses of Assembly? Because they still have the power to investigate, as we know. And in the case of Edo, we see the kind of bigotry that has taken place, where they just pronounce local government chairman, come and submit your income and expenditure. Where they find you wanting, they remove you. What is Algon's role in all that is happening? You heard the Attorney General of Lagos, what he just said. You listen to, I'm coming to Right Honorable Enefiok. Yours is, what is the issue? Why is Algon not taking up the responsibility of ensuring that, and Nigerians knowing why these funds have not been released directly to local governments?
Well, thank you very much. Thank you. First, I would like to tender the apologies of the national president, who is supposed to be here to sit on this panel, but is unavoidably absent. He had his re-election last weekend. Now, for Algon, first, this conversation is about us, the local government. This effort by MBA is to ensure that the local government has a space to breathe. So on that note, I'd like to kindly register our profound gratitude to MBA for these efforts you are making to ensure that the grassroots governance is back to life. Now, on the judgment itself, first, Algon welcomed this judgment with a lot of enthusiasm. Beyond Algon, Nigerians welcomed this judgment. And immediately this judgment was delivered, the role Algon played from July 11 is to continue to prepare local government councils for the tax ahead. Because you hear Nigerians saying that, oh, even if they send these monies to the local government, they will mismanage them. For us, that is still a speculation out there because the money hasn't get to them. So for our role since the judgment was delivered, there was an presidential implementation committee by the federal government, which Algon is a member. The committee has mandated Algon to make submission on certain areas, which we have promptly done. So we still await the committee to file in report, and then we take it up from there. And for what happens at the local government as regards some of the comments have been made so far, I know for sure that when I was in the council, yes, SUBEB is in charge of recruiting teachers at the local government, but for the state I come from, 100% of the salaries of these teachers were paid by my local government. There was no joint payment of these salaries. The only areas where
the state come in sometimes is in the area of providing infrastructure. And the counterpart funding of SUBEB, local government funds are also used to counterpart the funding of SUBEB. And the state primary healthcare agencies who are saddled with the responsibility of managing the health workers at the primary healthcare centers, the local government pays the salaries of this workforce 100%. So to say that actually the reason for the state joint account is because local government cannot cater for the salaries of this workforce. I speak for the states I know. I do not think it's reasonable enough to say that the local government will not be able to cater for the 100% salaries of this workforce. I make bold to say here that the funds accruing to local government is enough to pay workers' salary. So for me, for us at Algon, we are ready to take up our full responsibilities, and this conversation is not about usurping the power of anybody. It's about obedience to rule of law. It's about allowing law to take its course. We have said it here that look, the foundation upon which democratic system rests is the local government, and of course the foundation upon which every economic policy rests is small and medium scale enterprises that are domiciled in the local government. As long as the local government is ineffective, those indices remain ineffective and development can never thrive.
So you can clap. So first, you're a member, Algon is a member of that committee. Now, two, what I get from you is they should not gaslight local governments with payment of teacher salary in the past and payment of health worker salary. Because as it is today, you can pay. That's the point you have made.
That's the assurance I'm giving Nigerians.
You're giving to them. Right Honorable Enefiok, you are a fantastic speaker. And I'm sure if you followed, those who followed your time in Akwa Ibom. Section 7, as it relates with the local government. Why do you think that a lot of persons are afraid to let this process seemingly flow and allow, I don't know why you're smiling, but I will guess, and allow the local governments become both financially and administratively an integral part of governance in Nigeria?
All right, thank you, Malik. We thank God for the grace to be here. The president of MBA and distinguished ladies and gentlemen, first let me commend the president for living up to his billing in making the MBA a proactive bar in addressing issues that affect Nigerians even before those issues get to become a menace. Now to why yesterday I had the opportunity of attending a book launch of IGP Solomon Arase, and former President Goodluck Jonathan made a statement and said, until Nigerians begin to demand for good behavior from their leaders, that will continue to have the kind of leadership that we have today. I'm in a little bit of a dilemma because concerning the question you are asking me. One,
I'm asking because of your experience as speaker. You settled a lot of conflicts between local government chairmen, House of Assembly members, councillors, but still there was no flow across the country.
Okay, we've had the fiscal, my point is this, first we've had the fiscal autonomy for local government. Finances will not on themselves provide the necessary infrastructure that we need. And so we have people that are the directing minds and wheels of the local government, which are the operators of that local government. And as of now, there is no administrative autonomy for local government. And when we don't have that administrative autonomy, the implementation of the fiscal autonomy is going to continue to be a burning issue. For instance, we've heard in local or in some state where the chief executives have, through the instrumentality of the law made by the houses of assembly, have circumvented the judgment of the Supreme Court, in the sense that they have made provisions in maybe coming under the exercise of the powers granted by the Constitution for the State House of Assemblies to make law for the composition, good governance, and finances of the local government. They have made laws, and until the courts have come to pronounce otherwise, those are the laws of the land in those states. And let me pause here to thank the judiciary, the Supreme Court, in coming to the aid of the local government, what the legislature could not do. I recall what we went through during the Fourth Amendment. I was not in the House of Representatives then, I was only Speaker of the House of Assembly, but we had a body conference of speakers of State House of Assembly. For the very first time, because of the thorning issue of autonomy for legislature, autonomy for judiciary, and autonomy for local government, there was for the very first time a meeting of the Conference of Speakers and Governors Forum. And you bet you would want to know what transpired in that forum. There was a heated argument where the governor said we should not vote for the autonomy of the legislature, autonomy of the judiciary, and the autonomy of the local government. But we had to take a position, a compromise, as at then, to say, okay, we cannot give you all. We need to give you some. And so in our own thinking, led by the present governor of Ebonyi State today, who was the chairman of the subcommittee, the argument was that, okay, let us take the autonomy, financial autonomy of the judiciary, financial autonomy of the legislature, by which in the next alteration, the legislature would now be bold enough to give autonomy to the local government. And it became a serious issue at that negotiation. Even with that, we could only succeed on that score. So as it is right now, until we have the autonomy administrative autonomy of the local government, we are going to have this challenge. Until we have autonomy of the legislature without going cap in hand begging the chief executive for approvals, then they would always pass the law that would be at the whims and caprices of the chief executive.
Thank you. There was a reason I came to you. Now, Attorney General, sir, you listened to what the Attorney General of Lagos State said. They are not the problem. The judgment, you went to court, the judgment was given. What is stopping you from directing local governments to submit their accounts instead of setting up panels upon panels upon panels?
Thank you very much. First and foremost, the judgment fundamentally determined two things. One, to ensure democratically elected local government administration at all levels of the local government. Two, the financial autonomy. Now, in respect of the first one, all the states pleaded that by their laws, they needed time to follow the statutory procedure of conducting the elections, which we all agreed, and 3 months was given. And by the end of October, apart from, I think, Osun, all other states conducted elections, and we have complete local government chairmen and councillors in Nigeria now. Coming to financial autonomy, there are a lot of technical issues here and there. With greatest respect to my big brother, the Attorney General of Lagos State, It's not the problem of federal government. Even at the last Federation Account Allocation Committee meeting, the state governors, through their representatives, were there pleading with the Accountant General to allow them to submit the accounts on behalf of the local governments on the basis that they guaranteed a lot of facilities for the local governments, and that if the local governments are allowed to do that on their own, there will be a problem on their heads. So because of that, they have been pleading. But we are insisting that no, central bank must do it. Unfortunately, the last I spoke with the president of the association, it's unfortunate he's not here. I don't know if his representative can even send a message to him now and confirm. The last thing he told me was central bank must carry out some checks in respect of the identity of the local government chairman who is supposed to be, because in local government system as it stands now, you find out that the director of finance and accounts of a local government A may be an indigenous of local government E, going by the present system in place. So there is need for all those things to be corrected. And those are the things the committee, which comprises of ALGON, Governors Forum, are doing almost on daily basis, interacting to achieve the desired result. And further to that, the Accountant General has never for once said they're not going to send money directly to local government. In fact, every month they keep on asking, but opening of the account has a lot of process to follow before you do that. Unlike commercial banks that are willing to do that within 24 hours. And commercial bank is not an option for now.
Okay, so if I get you, you have, you are okay with the decision of CBN to verify the people who are signatories to the accounts. You don't need that verification. The governors, central bank, central bank, CBN is here. Wonderful. We will solve this, we will get to the end of this matter. Let me come to you, sir, quickly. I know, but wait. This is why we are here. Put it off. 2 minutes. CBN, how are you, sir? The Supreme Court gave a judgment. It is being varied. What powers does the CBN have to ask the questions it's asking the local governments to do?
Well, as we're all aware that the central bank is a creation of the law and is expected at all times to obey the law. And as it stands today, criticisms or no criticisms, we have a judgment of the highest court of the land. And it behoves of everyone to comply with this judgment, because it is only maybe to the Almighty that you can now appeal after this court. Well, one thing is this, the CBN has banking relationship with local governments just as it has with state governments. And it's our responsibility to maintain these accounts in accordance with the rules and regulations we have already put in place. So, anyone who is going to be a signatory to an account needs to be profiled. And profiling in the banking industries means you carry out KYC or customer due diligence, on the person. So it is our duty to do this, and we've been working with the Office of the Attorney General.
CBN or security agencies or judiciary? Is it just CBN?
Say that again?
Is it just CBN, security agencies, or judiciary?
No, as bankers, we do ours.
Okay.
Right, on our own.
How long will it take that process?
It's a very short one, because
what
we need to confirm is that the person presented to us is the right person, and we have established identification documents that we need to.
Who are you asking that question?
The account opener, the local governments. We have accounts for all these local.
Have you written to them?
Yes, we reached out to them.
Algon, no, just straight. Have you received any such letters?
Well, sitting here, I can't confirm.
Okay. President MBA, and I need protection. The Lagos State Attorney General is threatening me.
I can't confirm such communication has been received officially. And again, assuming without considering that of Algon, I have opportunity to be working as his technical assistant, has asked CBN to do, he doesn't really actually need to do that. CBN has his laid down procedure to his last 48 hours.
Chairman, just a minute. CBN, back to you. I can confirm, I can verify. No local government, I was just asking for form, but I can tell you, has received any letter from CBN asking to verify the identity.
No, when you are talking of letters, we don't write letters to customers. We issue guidelines. You understand? It's now behoves of people, the public, to comply with our guidelines.
Have you met with the leadership of Algon?
We do not need to. We don't go out after our customers. It's not our duty to do that. The law is very, very clear. Section 27 of the CBN Act says Central Bank may open accounts for federal government, state, local governments.
So we don't know when this process. We don't know when this process will complete.
Sorry. Central Bank is not in the art of marketing customers.
I just asked a simple question too.
Yeah.
We don't know when this process will be completed. From your comments here.
If Akoko Northeast local government approaches Central Bank Akure branch, it will be done within 48 hours.
Are you hearing now?
All Algon needs to do is to encourage its members to approach the central banks located in the various state capitals.
We're making progress.
That's what
because they seem not to know what to do.
So thank God for MBA for this platform. You are now telling Algon. So you can quote me that if you approach central bank within 48 hours, your problems will be solved.
So back to you, SAN Ebu. You have listened to everybody. And even with all the flowery words, I believe what is happening is deliberate technicality to prolong the process, which should ordinarily be a seemingly direct, straight, not touch-us in ensuring that funds go to the local government. With what you have heard, what will be your conclusion in 2 minutes?
Thank you very much. Beyond the judgment of the Supreme Court, you discover that most states have legislated out of the functions of the local governments. Virtually in all states, matters relating to markets, matters relating to cemetery, parks and garden, advertisement, everything that local government should do under the Constitution has been taken over by all the states. So we must go beyond the Supreme Court judgment in demanding for enforcement. MBA as a body, all our branches, activists should also file suits following what the federal government has done to restate the autonomy of the local government. And after that is a system of election. So long as the governors control the process of how leaders emerge in the local government, even if you give them financial autonomy, they will go back to square one, not being able to implement projects that will benefit the people for the purpose for which the judgment was granted.
Thank you.
Thank you.
Honorable Attorney General Lagos, one but final word. There's a state economic council. The economic council of every state requires that both the state and local governments sit down from time to time to look at issues and address them. Some of your colleagues are turning the state executive council, economic councils into a new joint accounts process, opening accounts and telling local governments to put money inside for projects. Is that a normal process? Is that a normal thing? Is the federal government asking you to do same in your NEC meetings?
Well, thank you very much. Well, I'm not aware of that, and I can speak for the state of Lagos that nothing of such happened. We have a joint working relationship very well with the local government, all the local government in the state, and no such things happen.
Something. That's good, because that's also not different. Ladies and gentlemen, we may not be able to have all the time, but I think one takeaway from here is that we need to quickly agree that the process of ensuring that the Supreme Court's judgment is adhered to is slow, and many people do not know the reasons why. Today, we have some information, because tomorrow that information may change depending on who you are talking to. So, Algon, they have asked you, it's on national TV. CBN has said to you, take your account information and send to the nearest area office of CBN so that they can do their verification and open the account. That is what they have said. So for me, I'd like to thank all my panelists for coming. Because of time, we need to go into the next session quickly. But I think it's a conversation that will continue, and it's a conversation we hope will bring and add value to the Nigerian system. Right Honorable Enefiok, thank you very much. Mr. Pedro, the Attorney General, thank you for your protection. Daddy, Honorable Justice, tired but not tired. Sam Akala, very vibrant chairman, thank you for representing the President of Algon. Ladies and gentlemen, God bless you all. Sorry, a photo session, please, quickly. Sorry, just a quick one here. Photo session here. Sorry, Attorney General, sir. So please, just a second. Photo session here. Yes, just one here. Just here. They want to keep the records of this conversation. The NBA president, please. And he will be presenting plaques right away. Okay, let him come. Then let him stand in the middle. Just come this way. Then he will be presenting plaques. Okay, but you stand in the middle. Okay, take this picture quickly, and then the chairman of the committee will present plaques. While standing, please, the plaques. The plaques. Okay.
My Lord, I present this with the compliments of the Nigerian Bar Association to you for graciously agreeing to present the keynote address which set the tone for this conversation. Thank you so very much for agreeing to do this for us. The Honorable Attorney General of Lagos State, this plaque is presented with the compliments of the Nigerian Bar Association for you to taking out time out of your busy schedule to be here. I didn't think you were going to make it. Thank you so very much. Yes. I present this with the compliments of the Nigerian Bar Association to you, Honorable Onofio Cloak, for agreeing to be part of this panel discussion, and also for agreeing to moderate the next session. Please, representative of the president of the Association of Local Governments of Nigeria, please accept this plaque with the compliments of the Nigerian Bar Association, and also we hope that this conversation will help make it easier for the chairman of the Local Government Council to take full benefit of this judgment of the Supreme Court by approaching the Supreme Court. But then we'll have our fears whether they will have the boldness to do so. Thank you so very much. Thank you so very much.
Thank you very much. Thank you very much, panelists. A round of applause for them once again as we go and prepare straight into the next panel, which will take us another 20 minutes. I'd like to respectfully invite a gentleman of culture, a fine, refined legislator, added value to the generation of young men in this country. He will be the moderator of the next panel. Right Honorable Onofiok Luke Akpan. A round of applause for him, please. Sit here, let me give it. This is CBN. This is 2. This is Code of Conduct. Spain is not here. NFI is here.
Okay. Who is representing the NFI?
That's
For the second meeting.
Sorry. The president, sorry, sir.
CPM, don't go, come. Who be the president from NFI? Huh? Okay, just stay and take before the person. Okay, it's the next session, okay. Yes, go.
On behalf of the Nigerian Bar Association, this plaque is presented to you for your rich contribution to the State of the Nation Discourse today.
Thank you so much.
Thank you so much, sir.
So, the bag, they'll give you the bag.
I think we will have to give just 1 extra minute for us to exchange pleasantries, after which we would please request that we please take our seats for us to resume the next panel session discussion. Our time will soon start to count. We've already done 20 minutes out of our 60 seconds. Remaining 38 now.
Please, let's settle down and have our seats. The next session is starting right away. Photographers, please excuse us. The moderator is already. Please, photographers. Please, photographers. After this, please, you'll excuse us. Right Honorable Enefiok, you have. Right Honorable, you can go ahead, please. The floor is yours. Yes. Just go ahead and call the participants.
Please, we are going into the second session, the second panel session for today, and we are going to be looking at the fiscal autonomy for local government, legal and institutional mechanisms for enforcement. May I please request that we all may be seated. My crave your indulgence for all of us to please take our seats as we resume the next panel discussion. The discussants in this second panel are, we have Mr. Alada Kofo, the Director, Legal Services, Central Bank of Nigeria. Mr. Kofo, please. May I please invite the Director, Legal Services Department, Central Bank of Nigeria, to please come up and take his seat as one of our panelists this afternoon. May I invite the Chairman, Code of Conduct Bureau, Dr. Abdullahi Usman Bello, to please come up. Our lead discussant this afternoon in the second panel would be Tochukwu Nweke, Senior Advocate of Nigeria. Tochukwu Nweke, please. May I invite the Attorney General of Ebonyi State, Dr. Ben Odo, to please join the panel. Dr. Ben Odo, please. May I request the Attorney General of Kaduna State to please join the panel. The Attorney General of Kaduna State, please. Pardon me, sir. The President has given me powers to conscript. Then the representative of NFIU. Pardon me, I'm still looking for the name. The representative of NFIU. You're all welcome. Now, our subject of interrogation this moment, this early afternoon, is fiscal autonomy for local government, legal and institutional mechanism for enforcement. May I please request Tochukwu Nweke, Senior Advocate of Nigeria, who is the lead discussant this afternoon, to please take 5 minutes to give us a synoptic view on the legal and institutional mechanism, both at the federal level and what the state needs to put in place to ensure the enforcement of this judgment of the Supreme Court. Mr. the Senior Advocate, sir.
Your Excellency, the President of the Nigerian Bar Association, all protocols duly observed. Thank you for this opportunity to discuss this very pivotal issue. With respect to the financial autonomy of the local government, the Supreme Court has handed down a judgment, so that issue is no longer subject to debate with respect to whether there should be autonomy, financial autonomy of the local government. The issue is now about implementation. But there are questions surrounding this implementation. First of all, we have to look at the constitutional structure. What structure do we have in the Constitution to make this judgment implementable? Now, first look at Section 7 subsection 1 of the Constitution, which gives the House of Assembly of a state the power to legislate on the composition, structure, and finance of the local government. Now, also understand that local government does not have the full complement of an independent tier of government. At the federal level, you have the legislature, you have the judiciary. At the state level, you have the legislature, you have the judiciary. At the local government level, you don't have the judiciary. The legislature, with respect to bylaws, is the councillors, but the legislature, with respect to lawmaking, is the House of Assembly of the state. Now, if you marry this with Section 7.1 of the Constitution, that gives the House of Assembly of the state the power to legislate on the finance of the local government, it means that when you talk about financial autonomy, you can't really implement that without the House of Assembly of the state. Now, you come down to Section 7, subsection 3 of the Constitution. Now, the Constitution says that the local government shall participate in the economic planning and development of their area. In other words, they should participate with the government of the state in the economic planning and development of their area. You go to the fourth schedule to the Constitution, look at paragraph 2. What does it say? That local government shall participate in the government of the state they shall participate in the government of the state with respect to primary health care, primary education, and all of those. Now, what this means that there is some level of marriage, synergy between the local government system and the state government. By mandating the local government to participate in the government of the state with respect to certain items, primary health care, primary education, and by also mandating them to participate in the economic planning and development of the area with the state government. And then with the House of Assembly having the sole power to enact laws on their finance, what you are going to have, there will continue to be that synergy, that marriage between the local government system with respect to finances and the state government. So to just throw a little light on this, for you to achieve full financial autonomy of the local government, we need to come back to the Constitution and amend it. Insofar as they've not given the local government their own legislative body which can make law independent of the House of Assembly, you keep having that confusion. Now, what this means, taking it further, is with respect to the finances of the local government, in regard to the primary health care, primary education, and all of those, there must be that intervention by the local government or by the state on those issues. So therefore, you can't really separate completely the powers of the state and the local government with respect to finances in those areas.
Thank you very much, the Senior Advocate of Nigeria. I'll still come back to you because by way of mention, you have spoken on the role, though not full legislative role, of the local government legislative council. I will come back to you on that, but let me go to the Attorney General for Kaduna State. The Attorney General, sir, if not for the purpose of legislating, at least for the purpose of performing a check and balance on the chief executive officer of the local government, these are the chairman, the vice chairman, how best can we reposition the local government legislative councils to make sure that they act as a watchdog, a proper one for that matter, considering the development that we have had today on financial autonomy, money that will be going straight to the local government. So how can we position the local government legislative council, starting from their elections, the kind of individuals to be elected as councillors who will now go to form the local government finance and general purpose committee? How can we best position them to perform the roles as watchdog on the chairman, sir?
Okay, thank you so very much. First and foremost, there has been a lot of hue and cry about this autonomy of the local government. I do not want to go so much or deeply into that anymore. What is most important with regards to what we are seated here for has to do possibly with the fiscal autonomy. When you look at the fiscal autonomy quite clearly, you will have to inject so many factors or areas that will enable the local governments to be able to function very well, so as to enable them to actually take their place in price of places. Now, the most important thing that these local governments will have to do with respect to their local council is to look at the IGR level. One, the IGR is one that the local governments are not so much having concern or do not place emphasis on. When you look at it, most of the times they always want to wait and ensure that there are allocations from the federal level, and then when it comes to the states, with regards to how it now gets shared amongst them at that particular level. And then the legislative council at that particular level do not seem to have a control of what they should do or what they ought to do at that particular level, considering the fact that most of them get into those seats with the influence of the states, and so they get scared with regards to what they ought or what they should be doing. Then the other aspect of it that will also ginger them to also have that fiscal autonomy in doing what they ought to do is to look at the PPP level. They will be having more recognition if they are able to partner with private sectors and ensuring that at least they are able to generate their own revenue without really placing reliance so much at the center and of course at the state level. So talking about all this, coming to the local legislative council, you will discover that yes, they will want to perform, but to what extent will they have the powers to perform? They are subjected to the whims and caprices of those who brought them in, and it becomes difficult for them to perform their function. If they need to do so, they will be tampering with their seats. Indirectly, they will be challenging the powers that brought them in. So they have nothing to do or to contribute much than at least to listen to those who beat the music, those that brought them in.
Thank you very much, the Attorney General. You are actually hitting the reality of the moment. I will come to you on the politics of the local government and how best that they, as chairman, can be independent in exercising the functions of their office. But let me go to the Central Bank of Nigeria, and thank God we have our own and a legal mind who is here representing the Central Bank, and no other person than the Director of Legal Services. Director, sir, Section 39 of the Central Bank of Nigeria Act empowers the Central Bank to act as the bankers to state government, federal government, state government, and local government. Section 40 of the same CBN Act empowers the Central Bank of Nigeria to act as agent of federal government, state government, and the local government. In my own estimation, personal opinion, I believe that the Central Bank of Nigeria has discharged that responsibility effectively to the federal government. It has discharged that duty effectively to the state government. And now with the change in dynamics of fiscal measures as it concerns the local government, how best can the Central Bank of Nigeria, in light of the challenges that we have, in light of the Supreme Court judgment, how best can the Central Bank of Nigeria act as agent of the local government as to ensure the enforcement, as one of the institutional framework to ensure the enforcement of the Supreme Court judgment, sir?
Thank you for the question and for preparing the preface for the answers to your request. You know, having set out the statutory powers or responsibilities of the central bank vis-a-vis banking relationship with local governments, state and federal governments. Yes, it's true that we are top-notch with federal government and state governments, but I think my response will still be steeped in my initial intervention before this panel, which is the fact that you open an account for a customer that approaches you. That is what we do. And if you look at the wordings, if I'm right, the wordings of those sections that you have set out is actually more of a discretion. I think the word may is used in those sections rather than shall. You know, so as it stands today, local governments still have, if they do, have accounts with commercial banks, just like some state governments do. It is only federal government, ministries, departments, and agencies who, as a result of the TSA policy, that is Treasury Single Account Policy, that came in 2015 thereabouts, they are mandated to move their funds to the Central Bank of Nigeria. So what we can do Well, I would just say, not we as central bank, what local governments should do is what has been started by Algon. Thankfully, we have that umbrella body that has been acting for them. And I've just got confirmation from the bank that Algon has approached the central bank and accounts have been opened for local governments. What we are now waiting for is who among the 774 gentlemen will bear the cat. You know, and latching on what the Honorable Attorney General of Kaduna State has said, the problem is, when are we going to banish that fear of the executive governor of yada 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 state over and the looming influence, you know, that is looming large, the influence that is looming large over these various chairmen of local government. When are we going to take care of this and permit some freedom that will enhance or ensure the autonomy that we are talking about now? It is one thing, we already have the judgment of the Supreme Court that said this. We have established framework, you know, that can be used, and some of these you have cited existing in Central Bank of Nigeria Act in our relationship with customers. So it is just now who comes before us. So Central Bank is now calling out, to use that language, the 774 gentlemen to come before us and carry out their KYC so that the accounts can be perfected. Let it be noted that no account can be operationalized without the prerequisites. It can never be done because Central Bank too is on the neck, so to speak, of deposit money banks to ensure that CDD, customer due diligence, is carried out before they can operationalize any account.
Thank you very much.
So CBN is waiting for local governments
to approach it. Dr. Bello, I carefully wanted to keep you for the last, but I would come to you before I go to the Attorney General of Ebonyi State. Dr. Bello, precisely on the 14th day of February 2025, we know what that day represents. You paid a visit to the president of NBA on Valentine's Day, sir. And on that day, you spoke about strengthening the relationship between NBA and the Code of Conduct Bureau. You did not come bearing any gift for the NBA. And so we believe that you were holding that gift to come and present to NBA today. And by this presentation, we know that you are going to give us that Valentine's Day gift. And to you, the gift we are asking of you today as NBA is, the mandate of your office is that you should work to uphold the highest moral standard of public officials. That is what you are mandated to do by reason of the establishment, extant law that establishes the Code of Conduct Bureau. Now, we've had a situation where some governors, in some cases, said, we don't want this autonomy because we don't want the chairman to go to jail by way of EFCC after their tenure of office. And then in one state, in one of the African countries, not in Nigeria, the local government chairman stood up and said, if the governors have been going to jail, so what stops the chairman from going to jail? And then again, we had a case where a chairman is ready to keep his seat but violates the law than for him to stand firm on what is right and loses his seat and then gets to be free at the end of it all. All that points to the issue of morality. Under the pressure that they found themselves, just like Attorney General of Kaduna has said, in acting according to the whims and caprices of the powers that brought them. What words do you have for chairmen of local government? What efforts have you put in place or do you intend to put in place to ensure that they don't get to fall in trouble? That there is a saying that prevention is better than cure. What effort, enlightenment, what have you done to get the chairman to understand, chairmen of local government to understand how they have to live up to the highest moral standard?
Okay, thank you very much for the introduction. Like you said, the Code of Conduct is to ensure compliance with the Code of Conduct in Nigeria. It's enshrined in the Constitution as well as the Code of Conduct and Code of Conduct Tribunal Act. So what we are doing at Code of Conduct, first, like you mentioned, prevention is better than cure. So if all local government chairmen are going to declare their asset to us, And then we are going to analyze that asset declaration. We are going to verify it at the beginning of their tenure. And then at the end of their tenure, we are also going to get that declaration. We are also going to verify it. So if there is any increase in their net worth that cannot be accounted for by their known sources of income, then they are going to come and explain to us, how did you get this amount? For a local government, for example, you are earning 5 million, maybe 10 million or so. So then we saw that you have increased your net worth by 100 million, 200 million. Then we come and ask you, how can you account for the excess over your known sources of income? If you cannot do that, then we can take you to court and get that asset forfeited. Then that will prevent local government chairmen from even committing corruption or fraud in the first place, because you know that CCB is here to verify that your assets are like this, and then at the end of your tenure, we are also going to verify it. So that's one of the major key things that we can do to prevent mismanagement of funds, if you know that you are not going to go scot-free. Apart from that, if, for example, we receive intelligence about a local government chairman that he has acquired wealth illegally, then we can commence investigation as well on his activities. Right now, my focus, or by the focus of CCB, one of the focus is local government chairman, because we know that with the enforcement or with the implementation of this policy, a lot of local government will have a lot of money. So what we are trying to do is that we are trying to get intelligence on this local government. Anybody that is living beyond his means, then we can commence investigation immediately. Let me even say it at this forum, that right now we have even commenced investigation on one of local government chairmen. We have seen his declaration. He has not declared a lot of assets. And now we have identified some assets that belongs to him. So that person, we are trying to investigate and find out, can you explain how you got this just by becoming a chairman of local government? So by the time we start doing all these things, it will go to the local government chairman that you cannot steal money and just go scot-free. That's the message that we're going to tell them. But before that, we need to enlighten them, because some of the local governments are not even aware of the provision of code of conduct. So what we are trying to do is that we are trying to do a lot of enlightenment. We are trying to do a lot of education. We are not after a public servant at all. And that is the message I want to say here. We are trying to enlighten you to know the purpose, to know the mandate of the code of conduct, so that you don't fall victim to the offenses of the code of conduct. So that's one of the key things that we are trying to do. Enlightenment, we make sure that you are aware of it. If you still go ahead and commit fraud or corruption, you know that we are going to investigate you, because right now the focus of the CCB is a law enforcement agency. We have all the powers and privileges of investigation. We are going to go and do it. So that is the message that we are going to
Thank you. Dr. Odo, as the Attorney General of Ebonyi State, things have changed. This is going to be a little bit personal. You are my friend. Our time is up, but I have been asked to inform us that the next 10 minutes would be for questions and answers. So the floor would be opened in the next, after the presentation of Dr. Odo, for members of the audience to please, either you have a question, you have an answer, you have a suggestion, or you have an input to make into this discourse. Dr. Odo, as my personal friend, I know you always like to leave a legacy behind any way you serve. Now, in this time of financial autonomy for local government, as the Attorney General, as the Chief Law Officer of Ebonyi State, what advice would you give the governor, and what suggestions would you make to ensure that we put an adequate institutional mechanism, institutional regime on ground to ensure the implementation of this autonomy to serve the ultimate aim of developing the local communities, the grassroots, so that we can help stop and stem the tide of the challenges we have in our local government, like insecurity, poverty, and the rest.
Thank you so much. I defer to you, and our chair, the president of MBA. Let me align myself on the plank of protocols that have been established. My advice is very simple, sir. You see, the man from CBN made a comment. Fear, palpable fear, from CBN, from the governors, of what the local government chairman may do with the money. And my advice is very simple. let us have a uniform local government administration law.
Sorry, DAG. Why is the federal government not afraid of what the governors will do with the money?
I'll give you an example. I'm coming. So if we have the local government, uniform local government administration law, it's going to help this fear disappearing. South Africa, Ghana, they have uniform law. And then this law is also helping them. Now, some of these governors have not had the first port of call should have been to have meeting with the chairman, the NOGE, and the bodies that they have joint account with the aim of having laid down procedures for the implementation of this. This will make everybody to have control of the process and to buy in. If we do so, I give you an example. There are some local government chairmen that you release this fund, and these are deepest fear of these governors. I must be sincere with you, and they will do away with this. For example, I won't mention the local government, but in my state, we are compliant. The governor, the Ebonyi state, have been releasing the fund once we receive it to the local government direct, once we receive. But there are some local governments that, after releasing that, the local government chairman will disappear with the fund. In fact, some lost their bid to return back because of this. So if we have this first, my advice, stakeholders meeting with the governors on how to effectively implement this, it is going to help in the implementation of the judgment, and then it's also going to help those people who have this palpable fear, to have control of the process. Then secondly, sir, you see, most of the problem we have is local development centers, some states that have extra local government by way of having the creation of development center and LTDA. For example, Lagos, they have 37 development areas. Ekiti, they have 19 outside their local government. Ebonyi State, we have 64 development centers outside the 13 local governments. And these development centers and local development areas are not captured in the constitution. It is when this money comes that this money is also shared between the development area. For example, like I said, in Ebonyi, we have 13 local governments and we have 64 development centers. And this money that comes is meant for 13 local governments. What happens to the 64 local government, 64 development centers? Now, when the chief executive, which is the governors, come together to sincerely have a meeting on the way out with the critical stakeholders, is going to solve this. 774 EFCC officials to the 774 local government to also serve as a watchdog to the local government chamber. If these things are in place, I assure you that this law will be effectively and collaboratively implemented, this judgment, and nobody will feel cheated, sir.
Thank you very much, Dr. Odo, and thank appreciation to other panelists here. But before we come for our final words from each and every one of us here, the floor is please open for contribution, not necessarily questioning, contribution towards this discourse. because this has been an advocacy that has run through months, years, and decades. We've not arrived at an El Dorado. What we have gotten now is financial autonomy. I think that the next line of advocacy would be how to have an administrative autonomy so that the people can well be equipped on how to manage the finances that gets to the local government. It seems that no lady has spoken in this hall since we started. So I recognize you, ma'am.
Thank you, Mr. Moderator.
Your name, please.
My name is Ruth Zekachat Skabruk Badum. I'm a member of the Unity Bar here. In fact, it's like you took what was in my mind and you mentioned it. I want to congratulate the NBA presidents and all the organizers for this program. Very laudable, very insightful, very impactful. However, I want to say that I am not happy that among all the panelists, not one single woman was deemed fit to talk about local government autonomy. My president, sir, moving forward, next month is Women's Month. I hope we organize something for women to come and talk. Please always take into cognizance, if you are clapping, clap well. If I'm clapping, if you are clapping, clap. Thank you very much. So for me, sir, I want to agree that there are 3 tiers of government. And the Supreme Court should not be seen to be a toothless bulldog that cannot bite. I was just sharing information with Algon here. The structure, from my own observation and having listened to all the panelists, there is a need for the National Assembly to bring out structure, because this money cannot be released based on the old structure. For example, most of these state governors have immunity, and the ladies that sat behind me before she left, this money cannot be released to commercial banks. Reason being that, why? Most of these state governors have committed themselves financially. And the moment that money gets there, if there is no specific destination, I heard somebody saying profiling. The local government needs to have profile. And I want to align my thought with the Attorney General from Ebonyi, that until we have this local government structure, he made mention of local government administrative law, so that we will have a uniform administration at the local level. The legislative will do their own, the executive, the judiciary, and the local government. Thank you very much.
Thank you very much, man. I saw a hand there. Yes, sir. Yes, sir, with the cap.
I'm Comrade Noah Atabo branch. My question and contribution, my question is directed to the ICPC and NBA. The apprehension of the public that this financial autonomy to the local governments, Nigeria is going from bad to worse in terms of corruption. And in terms of the welfare of the masses, things have not improved. It's getting from bad to worse. Most of us, 80% of Nigeria cannot feed, and the money is there. Now we are saying it's going to the local government autonomy. MBA, please, I appeal to MBA to do something, to be one of the major watchdogs, because the government institutions, including ICPC, they have not done enough to the fact of being the watchdog on these finances. Please, the public is still apprehensive towards the financial autonomy of the local government. Thank you very much.
Thank you, comrade. I will come to this row. The gentleman in front with a pinkish tie. I want a lady's hand in this row before I am being accused. Or should I have my glasses on? Okay, sir.
Thank you so much, Mr. Moderator. the President of the Bar, ladies and gentlemen, my name is Abiodun Aikomo. I'm the Attorney General for your state. The position here is not about the rightness or wrongness of the Supreme Court judgment. We do, as lawyers, we don't have an option. The judgment has been given, and the focus is how we should make it work. Now, in making it work, the question is, how will this judgment deliver effective local governance at the local levels? I want to disagree with my chairman, the chairman of the body of attorneys general. We cannot have a general law to regulate local government. By the nature of local governments, the peculiarities of local governments are not the same. A generalist approach will not work. Local governments are peculiar to different environments. So let us not have a discussion that is just simplistic or that is just treating the symptoms. Let us think about how, when the monies are eventually delivered to the local government directly and they have access to it, do they have the institutional capability to drive development at the local government? Those are questions you should be asking ourselves, not just about whether the money will go, whether they are being profiled. There are so many issues that we have not dealt with. So when we give the funds to the local government directly, it doesn't make any difference. So all these discussions are just isomorphic mimicry, just talking about symptoms without talking about the real issues. And I think we should focus on the real issues. Thank you.
Mr. AG, please, I will take you on that.
Okay.
Mr. AG.
I'm ready.
Mr. AG, NBA set up this platform for us to come and bring ideas on how to make it work. An NBA, and this is quite commendable because on that 29th day of August 2024, when Mr. President gave his inaugural speech, one of the highlights of that inaugural speech was the setting up of the local government monitoring committee. So the AG Oyo, you've talked about us talking about the symptom or not addressing the main issue. As the Attorney General of Oyo State, what would you think that would be done? What are the measures you think that could be put in place? What are the institutional mechanisms to ensure the ultimate aim and objective of local government autonomy, sir?
Okay, thank you.
And what are the practical steps that have been taken in Oyo so that we can probably take a cue from it?
Well, I will start from the last question. We have done a lot of work in Oyo, but we are waiting for the federal government's position. The judgment was given. If it was so simple, it would have been easy to implement immediately. The federal government set up a 10-man committee headed by the SGF on the 10th of August. The committee up till now has not delivered its report. But what we want to do in Oyo State is effectively to deliver good administration at the local levels. But there are challenges with that. For instance, before we go to where we are today, local governments are not on the same plane. In Oyo State, we have 33. There are local governments in Ibadan with more than 100 primary schools, and they have teachers to pay from their funds. We have local governments in the hinterland, in Oyo North, where you have very few people. So when those local governments were maintained as autonomous units, that was the era that the expression zero allocation started coming out, because some local governments, after paying teacher salaries for the local government, they cannot do any other thing, whereas some people have surplus. So we have to seriously think about what are the peculiar issues on a local government by local government. How do we deal with the generalist problems and ensure that there is even development at the local government? What about the capacity? Have you visited any local government in recent time and see the organizational structure? even when they have the funds, can they drive it? No. Driving it is not automatic.
Please, he has the floor. He has the floor, please.
Madam,
he has the floor. We have the floor. We have rules of engagement here.
It is not about emotions. It is about doing the right thing and building the right capabilities to drive it. And that's
Thank you very much, the Attorney General. Thank you. Thank you, the AG of Oyo. I would get to you, the gentleman in white. Those are the last. That is the last I would take here. Then I will go to this other row, and I will come back to the representative of Algon, and then we will have to close because this event was supposed to end by 1 o'clock, and I don't want to be a moderator violating the rules of engagement for today's discourse. So the gentleman in white, sir. The gentleman in white, sir.
Thank you very much, Mr. Chairman. I am Dr. Tanimu. A local government is supposed to be the grassroots administration. But in the operation of the system, it will appear the legal framework establishing the system was a bit defective. In the sense that if you look at it in the area of the definition of federalism, the Constitution only defines the federal system in Nigeria to consist of only the states and the Federal Capital Territory. It conspicuously took away the local government in the composition. As a result of this, it then became a situation whereby the local government then became...
with due respect, sir.
Yes.
We have arrived at where we are now.
Yes.
We have come through that long journey.
Yes, sir.
And we have arrived here.
Yes, sir.
And our trajectory is, how do we get to a development point?
That is what I'm coming
and so, what suggestions do you have?
What I'm saying is that the basic issue to be looked into is for the legal framework to be looked into holistically. That is in the sense that the local government is almost seen as an appendage. If you look at the provision of Section 7, which says the system of local government system by democratically local government is hereby guaranteed. Accordingly, each state shall ensure the existence of local government subject to the provision of Section 8 to establish under a law the finances, structure, composition, functions and establishment. In this situation, states have taken advantage of the fact that the Constitution has guaranteed that they have to establish a law that will regulate the activities of local government. And in that situation, it has now placed the local government as an appendage under the state. And that is why in most of the state laws, you discover that all areas we are talking about have been covered under them. The state law made provisions for the finances.
So, sir, what do we do? What do we do?
What we need to do is this. The local government ordinarily should not be placed under the state. Its existence should not be under the state. As long as it remains under the state, it will remain as an appendage.
Thank you. Thank you very much, sir. Thank you. We are grateful. I'll go to this row. I saw the hand of the Attorney General of Lagos State, and I would then take Monday Ubani SAN.
Thank you, Mr. Moderator. Like I said earlier, the solution to have full autonomy for local government, if it is so the wish of Nigerians, is to go and amend the Constitution. The Constitution as it stands today do not foresee autonomy for local government. So that is and you know, for if we say where we are today, which way forward? The way forward is for the State House of Assembly to enact a law properly to guarantee this autonomy. In my view, there is a substantial autonomy to local government, but not full. Like I said earlier, the Supreme Court has helped us to say you can't have caretaker anymore. Must be democratically elected. So that shows the administration is autonomous on that level. Finance is coming. However, like my brother A.J. Ebonyi said, the control of the local government council by the state governor or the state house of assembly is what can be addressed, so that none of these bodies, that means the state government, the house, can willy-willy decide to remove a local government chairman. That is the next autonomy, and to some extent we do have it even in the law of Lagos State, that if any chairman is found wanting to have breached, to have committed act of misconduct and needed to be removed, what steps do you take? You go through the council, which has its own legislative arm, the councillors, and once they confirm that this man as chairman must leave, then the leader of the council will now communicate to the chief judge of the state.
Thank you,
who will now set a panel. So if that such power is also reversed or included in the power of the House of Assembly of the state, because local government must be checked whether we like it or not. So if the House of Assembly found any one of them wanting, it is not for the House of Assembly to be a judge in their own cause and say this chairman is guilty of misconduct, must be removed. Sent to the CJ for a panel who will decide.
Thank you very
Likewise,
much.
Mr. Governor.
Thank you, AG.
So
Thank
that's
you,
the solution.
Thank you, AG. Mondo Bani SAN.
Thank you. This discussion couldn't have come at a better time like this. Presently, there is an ongoing constitutional review of our 1999 Constitution, and my humble self happened to be one of the consultants, and the issue has revolved around this issue of local government. How do we make the judgment of the Supreme Court to align with the provisions of the Constitution? And I'm very happy that the Attorney General of Lagos State has said the only way we can resolve this issue is actually looking at the Constitution. I'm happy that MBA is taking up this particular issue. This is one of the greatest things that can be done by a professional body like MBA. We need all the suggestions. Last Friday, we sat down with the local government officials from the national to look at the issue of education, health, that is not properly defined as the role of the local government. Which one are they as, ceding to state, and which one do they want to carry over, and then ensure that they pay the workers that will be under them. And we discuss and we're arriving at all those solutions. So the input of MPA in this particular ongoing review is clearly very important, so that we can get it right. But more above all things, if we do all the amendments and Nigerians are not willing to ensure that local government maintains its autonomy, because the governance at that level is what will develop Nigeria. Everyone is a product of local government. That we have insecurity in Nigeria today is because local government is not properly policed, and everyone knows it. That people are leaving the rural areas to urban is because there is no governance at that level. From 1999 to date, the governors have seen that money of the local government has become a honeypot, and they are making a kill of it. But Nigerians must arise and be awake and say enough is enough. The money for local government must go to local government, and we must monitor the chairmen to ensure that they use local government money to develop our local government in Nigeria. That's the only way we can move forward as a nation.
Thank you very much.
Thank you very much.
Thank you very much, Mr. Bani.
I saw the hand. Please, our time, with all more respect, our time is up. We have almost more than 20 persons who wants to still make their interventions, but we cannot accommodate all. Please, with utmost respect, please let's conduct ourselves with decorum. Thank you. We would give the representative of Argon the right of reply, because this bothers them.
Okay, thank you very much, moderator. It is not some sort of contest we're doing here. Just like I said earlier, this is meant to deepen democracy, the local government, and serve citizens of our country. I keep saying no Nigerian reside either in a state or federal government. Every one of us reside in a local government. Now, I just want to correct an impression by one of the speakers who said most of the local government administrators do not have capacity. First, the recruitment process into local government administration is handled by the state governors, assisted by attorney generals of the states. Therefore, the State Independent Electoral Commission, we all know that if election is conducted in a state, the parties of the governors wins it all, including chairman and local government. Therefore, it means that it is the state government that actually selected these officials. So I will be shocked here to hear that a local government chairman selected by the state government does not have capacity to administer the local government. Therefore, I want to just make quick point.
We are going to
assuage
issues.
Sorry, sir, just seconds.
Can you please round up in 30 seconds?
To assuage our fears of management of resources, Algon has gone to EFCC to pay a visit to say, look, EFCC, once this money begin to hit accounts of 774 local government, we as local government officials, we do not have immunity. Follow the money and ensure it is utilized in the interest of the citizens of Nigeria. Local government chairman can be picked from the office because they do not have immunity. Therefore, there is no fears as to a local government chairman will disappear.
Thank you very much.
So I thank you so much, and I want to assure us local government has capacity to administer and fight insecurity in this country. Thank you.
Thank you, representative of Algon. I will now come to the panel by which we will begin to put this event in the reverse gear. We all come from a local government. And then to some of us, we will return to that local government one day or the other. There are some people like, I don't want to mention their names, they're very senior lawyers here. They said, at old age, when I die, return me to my home. I know them, they've spoken with me, some of them are here. So we will all return to local government one day or the other, dead or alive. So with these new developments, with the dynamics, there is a beer that was manufactured sometime, that was produced in Nigeria some time ago with the word, with the buzzword final word, Satsembra. So the final word today from you, starting from the Attorney General of Kaduna State, what advice would you give to the administrators at the local government level in the light of the current realities? Just some few seconds.
So I thank you so very much once more, moderator. I will address that very quickly, but before then I want to align myself completely with what the AG Lagos State said. When this issue started, when this case was filed at the Supreme Court, the Forum of Attorney Generals met and we saw the danger ahead. All of us opposed and even filed preliminary objections to the competency of the action before the Supreme Court. However, it will amaze you to understand that within the very short period that we are talking about, some local governments also applied to join to oppose this autonomy we are talking about. Maybe not because they were opposing, because they do not really want it, but because of the constitutional logjam that we foresaw, and they also saw it. The problem is still lingering. This discussion must still continue, sir, because the problem will still be there.
So final
word here is this constitution has to be amended. We have to have this autonomy, as the Supreme Court has made this pronouncement. Let it be reflected there, and then the solution will be there. But in the interim, like I have had in my own state, in Kaduna State, we have had a board that has been constituted, and we have got to advise the state government on the way to go concerning the judgment of the Supreme Court, and we are addressing it so as to comply fully with the judgment, and that is in the interim.
Thank you very much, DNG. I know you're a public servant, but you come from the local government, sir. What advice would you give to your chairman of local government in the light of the present reality?
Thank you, Honorable Luke. It's not now that we're going to start. We have started doing that, and I actually want to call upon everybody here present that, as you said, that we come from local government, and I think we are men and women of influence in these local governments. Everyone seated here, maybe 50% have had cause to use his or our banking app today to actually send money to the various local governments. In order to reduce this burden on you, there is a burden that you have to bear and fulfill, which is be in touch with your local government chairman and councillors and steer them in the right way. Then I will be calling upon NBA that this discourse should go beyond what we're having now. The NBA is, I think, has a right and a moral obligation, legal obligation as well, to escalate this, or maybe to take this to a lower level, and that is by having something. As a forum, Algon may be the one to do this, local government chairmen, they are directors of finance, and a few councillors seated in a room and see how we can take this forward. The judgment is there, the judgments must be implemented for us to achieve some of the implications of this judgment, and that is a recognition of the fact that there is another tier of government. For the very first time, it is coming to the fore that we have a local government, or we have local governments that are closer to the people and have now been empowered financially to do things that they were not doing before, and for local government and councillors to write their names in gold when they have these resources and not cut the money away, trying to emulate the ills of others. Thank you.
Thank you very much. The AG of Ebonyi State.
Thank you. Mine is just to adopt the submission of AG Lagos and Monday Obani SAN, and also to thank the representative of Argon for assuaging our fear and for the assurance he has given to NBA today. And I want to say that the NBA Monitoring Committee on the local government should also serve as a watchdog in assisting the Argon to fully implement what they have assured us through their representative here. And once that is done, this thing is doable and it will be done. Thank you.
Thank you. Alenesek.
Thank you very much. I think the points have been made that there needs to be an amendment of the Constitution for this to work effectively. I think the NBA should champion this. We need to have clarity on the exclusive functions of the local government spelled out by the Constitution. They should have their own independent legislature, not dependent on the House of Assembly of the states. If all of these are done, I believe there will be clear separation of powers and they can have full autonomy. Without having administrative autonomy, it is not easy to achieve financial autonomy. You may have partial autonomy, but it won't be full or absolute. And my learned friend had mentioned the Anambra model, which to me is very commendable. The AG of Oyo made the point that some local governments do not have as much health facilities, as much primary schools like others. So some of them do not have the capacity to pay salaries to a lot of all these institutions. So what Anambra has done is to enact a law where the local government chairmen themselves come together and then decide on how much of their money they will pull together into a joint account for them alone. They're not giving the state. They pull resources together, and then that way they now apportion part of the money to the salaries of teachers, salaries of primary healthcare workers. From that pool, they're able to pay salaries and they won't owe anybody, because some have the strength, financial strength that others have. They don't receive the same allocations and they don't have the same number of facilities. So by pulling resources together, they're able to pay uniform salaries across local governments. So I think it's a model that other states can adopt to amend the Constitution.
Thank you. Dr. Bello, I know you would not want the chairman of your local government to fall foul of the law. And so what you have done to save the neck or save the pathway to governance of the local government chairman, please, we want you to share it to the knowledge of the local government chairman of each and every one of us seated in this hall today. So what would you advise the local government chairman?
I want to say two things. First, I'll address your question, and I also have a question for lawyers, because I'm not a lawyer, but there's one question I will ask you later. The first thing, like you said, I will advise all public servants, especially local government chairmen and councillors, to declare their assets. What we are going to do at CCB, we are going to verify those assets. But I am assuring you that verification is not investigation. So once you declare your asset and then you verify that this asset belongs to you, we are not going to look at you at all until the end of your tenure, or if there is an allegation against you, or if there is intelligence against you. But then, if you refuse to declare your assets, then that will trigger immediate investigation. So therefore, my advice for all public servants is for them to declare, because the law says you should declare, and we verify. And then after the end of your tenure, we'll go and check whether there is any increase that you cannot explain. So therefore, for 4 years, if you are a local government chairman, or 5 years, whatever, we are not going to come after you. But once you did not declare your asset, then you are showing us that you have something to hide. Then we can commence an investigation against you. Therefore, that is my first advice. The second advice, the one thing I want to say again is that on behalf of all the law enforcement agencies, the ICPC, the FCC, and CCB, we are ready. Once money starts coming to local government, we have the capacity to do it. Let me tell you that one advantage that CCB has over the others is that we have offices in all the states of the Federation. So by constitution, by the law, it says that CCB has to have offices in all the states of the Federation. Therefore, we are there on ground. We are there, we have allocation for monitoring, we have allocation for verification, so we are going to do our work, and we are going to do it diligently. That's one of the key things. And then my question, you have been mentioning immunity of governors. I'm not a lawyer, like I said, but the provision of the code of conduct is in the constitution. It says the president, the vice president, the governors, it listed the name of people that are supposed to declare their assets, and we are supposed to investigate. So also there is a provision in the constitution that says the governors have immunity. So my question is that which one supersedes? Does a governor have immunity under the code of conduct or not? I know this might be but I will allow you to go and think about it and know.
Thank you, Dr. Bello. We've come to the end of this session. Please, we sincerely regret our inability to accommodate those who had opinion, questions, and suggestions to have made. It is not our making. Time is against us. We sincerely apologize for that. We want to thank all the panelists for having found time to come and share their thoughts and share their ideas, and everyone who have made contributions to make this panel a great success. But something we have to take away from here is that we started a journey advocating for the strengthening of local government. We've achieved a part, which is financial autonomy. We should not rest on our oars. The next phase of advocacy is how do we begin the journey towards administrative autonomy? And that is very important. Today, the Supreme Court has given a judgment, but in our rule books, the issue we are discussing is still there. So we need to begin to engage the National Assembly and engage the state houses of assembly to ensure the effectiveness or the enforcement, because the enforcement part of the enforcement mechanism of the Supreme Court judgment is the amendment of the Constitution of the Federal Republic of Nigeria to delete that subsection on joint account for local government. Thank you once again, and may God bless us all. Please, photo session. Mr. President, sir, and chairman of yes, and all the other panelists, please.
Mr. President, members of ESCO, all former panelists, please come to the stage for your pictures.